Regarding the advantage of having a closed basin in the western Montana. So you mentioned something about 90,000 acre feet being provided as part of the settlement to the tribes, and so I have a couple of questions on that. What does 90,000 acre feet equate to in gallons?
It's roughly 340,000 gallons per acre foot, so I'm not a mathematician, but I'm guessing 27 million gallons, roughly. That's ballpark.
I think it's probably closer to about 30 trillion gallons, wouldn't you say?
You know, I just sat here and did that math in my head, so I'm happy to take your word for it as well. At the end of the day, it's 90,000 acre feet. An acre foot is the conventional measure of water. It's enough water to cover an acre 1 foot deep, about the size of a football field.
And this is Hungry Horse Reservoir that we're speaking of. And so 90,000 acre feet, 30 trillion gallons plus, an annual amount that can be reserved, or let's say leased, because this is considered stored water. And I'm curious, this is an agreement that's being put forth by the United States on behalf of itself and on behalf as a trustee for the tribe. Is the tribe considered a corporation in this agreement, or is this a...
I gotta be honest with you, we spent a lot of time on that in prior meetings. That is not a relevant question to these particular negotiations. As has been explained to you in prior meetings, the tribes have legal status both as a sovereign government and as a corporation, and that has no bearing on anything having to do with this agreement. I'm sure that there are people who would be happy to talk to you about that separately, but I would suggest we not take up folks' time tonight with that particular line of inquiry, because we've been down that road.
Well, I'm still confused, Jay. You say a sovereign government. Does a sovereign government really exist under another sovereign government? Is the United States sovereign also?
Under the 1832 case of Worcester versus Georgia, Chief Justice John Marshall of the United States Supreme Court described tribes as domestic dependent nations. It's been 180 years of jurisprudence recognizing that while tribes are not co-equal sovereigns with the United States, they still retain those attributes of sovereignty that are not necessarily inconsistent with their status as domestic dependent nations.
And this agreement that's being proposed, which I'm not in disagreement that an agreement come together, but you have, again, 90,000 acre feet of water in the Hungry Horse Reservoir, which is being provided as part of the settlement. And this water is also part of what can provide future growth for western Montana. Am I right?
Possibly. One of the reasons that the state is bargaining for access to 11,000 of those 90,000 acre feet is that the state spent 5 very frustrating and largely fruitless years trying to negotiate directly with the U.S. Bureau of Reclamation to contract to make some water available out of Hungry Horse. And we were not able to do so over a 5-year period, and so in 2010 the state made the choice to see what we could do in the context of these negotiations, to see if we could secure some of that water for development in western Montana off the reservation.
And so that's about 11,000 acre feet that the state of Montana is needing. Will there be the potential then for western Montana to be considered a closed basin, where the Hungry Horse in the future could have been the water utilized for future growth?
The effect of Hungry Horse on whether or not western Montana is a closed basin is an apples and oranges issue. The basin closure issue arises if there are sufficient existing water rights that the determination is made that there is not water legally or physically available. The largest factor likely driving questions of closure in western Montana has nothing to do with these negotiations. It's the Vistas dams down at Knox and Cabinet Gorge.
I was on the phone with the DNRC the other day, and I was a little confused with your answer earlier. They claim, and they claim twice now, that a well prior to 1962 is not required, is exempt essentially from being filed upon. They also claim that there would be a burden, if ever contested, if that is being utilized for beneficial use, that you would have to prove beneficial use. And if it's being used for domestic and or livestock use, then that would answer the question. Is it being used for beneficial use? So I'm confused. Earlier you mentioned that pre-1973 water rights must be filed.
Except for certain categories of direct from source, domestic and stock uses that under Title 85, Chapter 2, Section 222 of the Montana Code did not have to be filed in the adjudication. And it is that limited category of water rights that are valid water rights under state law, but are not necessarily documented in the adjudication, are the pre-73 rights that we are making the registration process available for. And unlike the post-1973 rights that John asked about, which if you choose not to avail yourself of the registration process, you lose your legal entitlement to water. These pre-73 rights, if you choose not to register them, are not lost because the state constitution recognizes them, the water use recognizes them as valid water rights, even though they were not filed. So what we're offering for the pre-73 rights is the opportunity to come on the books so that they can be administered and enforced if the people who have those rights want them.
Does the United States, corporate or not, for profit or not, for control or not, have priority in their place as a trustee and on behalf of itself have a priority over the tribe's, corporate or not, for profit or not, position on the water?
I'm not sure I understand that question.
The United States is a trustee, am I right, for the tribes?
Under federal law, the United States holds in trust real property assets, some real property assets to the tribes, namely land that is held in trust. The tribes also can hold land in their own name, but it is not what's known as in trust status. The Federal Reserve water rights that we're proposing to recognize in this compact would also be held in trust by the United States on behalf of the tribes.
Thus, currently, there is no Federal Reserve water right established or claim established on the Hungry Horse Reservoir, is there?
No, the United States filed in the state court system for its own water rights for the water in pounds and Hungry Horse.
When was this?
It filed it part of the adjudication, their claim priority date.
Candy, late 40s, early 50s?
Sometime in the 1940s was the claim priority date around the construction of Hungry Horse.
And is there a quantity of water that they're claiming that has been filed as well?
There are some issues with the way the Bureau of Reclamation filed those claims. They ultimately will need to be dealt with in the adjudication. However, what we are looking to Hungry Horse for is something that we've looked to federal storage facilities for in the vast majority of other Indian compacts, which is essentially augmentation water. And the reason we look for that, and we look for these ponds of stored water, is that what we are trying to do here is to find a way to bring the tribe's legally valid senior water rights that historically have not been exercised for a variety of legal and historical reasons, but that are nevertheless senior and legally valid. We need to bring them online in our settlements, and we need to do it in a way that protects existing use. And frankly, the only way, or one of the critical ways that we found to do that, is essentially to increase the size of the bucket. And so for the Crow Compact, for the Northern Cheyenne Compact, we included allocations from Yellowtail Dam in southeastern Montana. For the Rocky Boys Compact, for the Blackfeet Compact, and for the Belknap Compact, we looked at Powder Reservoir, which is another Bureau of Reclamation facility in central Montana, north central Montana. Here we're looking at Hungry Horse as well to augment the water supply as part of the balance that we are trying to strike between recognizing the tribe's legally valid senior water rights and the protection of existing use that is so important to the state.
And the protection of existing use, I think, has a lot to do with the future potential of growth. And when you have closed basins, that should...
Let me stop you there for a second, David, because the word that I'm using is existing, and the word that you use is future, and those are two totally different things.
Not when you're considering value of property, am I right? Existing use of someone's land also has a direct correlation to what water is available. When someone, as you said, is being protected for their existing water use, that's fantastic. What about the person a day after Congress ratifies this agreement as it's currently proposed, and now you have not the same protections going forward. How does that affect possibly the closure of the basin and the potential growth of future communities, the potential for future businesses, etc.? That doesn't seem to protect existing users in the bigger picture.
The scenario that you're describing, however, is fundamentally inconsistent with the legal framework that governs water rights in the state of Montana, which is a prior appropriation system. One of the fundamental principles of a prior appropriation system, which is the law in Montana and the law of most western states. It's a different system back east. But here in Montana, we have a prior appropriation system which by its very nature existing older uses over either existing or future junior uses. That is the law in the state of Montana. We are not affecting that. And in fact, what we're trying to do is essentially to protect those existing uses that are currently on the ground, that people have relied on and built up a way of life around, from the tribe's senior water right, that if we are not able to reach a negotiated settlement, could have significant and severe displacement effects and disruptive effects on those other existing water users because we live in a prior appropriation state.
Thank you, and I'm just curious to know with the Hungry Horse Reservoir, what date would be attributed to the right, being that this is 90,000 acre feet, being that this water is being given as part of the concession, I believe is what you said, what right then would be attributed for that water in Hungry Horse, leasable water, what year would you attribute to that?
The proposal, the way that it is structured, would have an 1855 treaty date associated with that water. The question remains whether Congress will ratify it that way. And that's ultimately a question that Congress will need to determine. And if they ratify it in a way that is different than what we have in the settlement, I would expect we would need to amend the settlement if Congress goes in a different direction. But the proposal as it stands is for an 1855 date associated with that water.
Which would be senior then to, I imagine, even secretarial water rights that have been provided. Senior to, I imagine, all water rights that have been provided to existing water users. Am I right?
We're talking about stored water, and once that water is stored, it is essentially out of the priority system. Whether it is an 1855 date associated with it, which is the tribe's treaty date, or whether it is the date that Reclamation filed on, which I believe is sometime in the late 1940s. Where the priority date matters for storage facilities is if a senior water right holder to that date, at the time that water is being impounded, has a need for that water. If that happens, that senior water right holder can make a call on the junior storage user to prevent that storage user from impounding the water. However, once that water is impounded and stored in the Hungry Horse, it is out of the priority system and not subject to call, irrespective of the priority dates. That's how stored water works under the law in Montana. One of the other major things that we have overlying all of this is the Federal Columbia River Power System, which includes Hungry Horse and Libby Reservoir, which has federal purposes of flood control and also for Endangered Species Act flow conditions that largely govern the operation of those reservoirs and that affect how water is impounded and when water is released. So we believe that as a practical matter, the kinds of concerns that you're raising about what the impact of this water or the priority date associated with this water might be on other existing users, we do not believe that there is a practical or a legal conflict that will arise because of how stored water works in Montana and because of the other federal law overlays that exist wholly independently from anything we're doing in this water rights settlement.
Future growth could possibly take place in areas of the Hungry Horse Reservoir by way of granted leases of that water to municipalities. Would you say that's a probability?
I'm not going to sit here and try to predict how likely something is or is not to happen in the future. David, if you don't mind, you've had the mic for a while. I'm happy to keep talking to you. If there are other folks who have questions, I'd love to give them an opportunity first.
Sure, thank you.
If not, you're welcome to hop back up. Chris.
Christopher's the actual name. Let's talk about closed basins if we can. This is not a closed basin, is it not? It's considered an open basin.
There are two ways you get to closed basins, well, three ways you get to closed basins in Montana, I suppose. One of which is judicial determination, one of which is legislative action, and one of which is administrative action by the DNRC. None of those things have happened in this part of western Montana. The Bitterroot is a closed basin by legislative action. The Upper Clark Fork is a closed basin by legislative action. I may be missing a couple of others. The Kootenai, the Swan, the Flathead are not closed basins under Montana law. And nothing we are doing in this settlement affects one way or another Montana basin closure laws. We are not in this settlement closing any basins.
Okay, the Flathead irrigation project and the water use agreement, pardon me if I don't keep up with all the acronyms, it has an appendix that stipulates the amount of water use. Now, of course, it's proposed and it's not in, and I understand that, but presuming that it goes through, those amounts of water that are going to be allocated through farm turnouts are locked. They are capped. The discussion has been that 80% of the beneficial use of the reservation water is for irrigation. If those are capped,
80% of the consumptive.
Consumptive use, okay. The consumptive use is capped. That is rather a de facto closed basin for irrigation development purposes, is it not?
No, I don't believe so, because there are processes available under the unitary management ordinance. If someone wants to go in and get a permit for a new irrigation use on the reservation, there is the ordinance process available to them to do so. Under the irrigation project, under the federal law that governs the irrigation project, you can't simply start irrigating new acres with your project water. Federal law doesn't allow for that. I'd be happy to hand that over to Jennifer if you want more details.
Well, I don't need details. I'm just saying that there are appendices that actually put limits on the amount of water for any given area that's under irrigation on the reservation. And how is that going to be altered by the ordinance maintenance?
What the water use agreement, the FIT water use agreement is intended to do is to strike the balance between the irrigation project water right and the tribe's in-stream flow rights. There was litigation between the tribes and the Flathead Joint Board of Control in the 1980s. The tribes won, the Flathead Joint Board of Control lost. That's what brought us the interim in-stream flows that have been put in place on the reservation since about 1990, which are known as interim in-stream flows because they're placeholders until we have a final settlement. What the Ninth Circuit Court of Appeals made very clear in that 1980s litigation is that because of the tribe's treaty language and the Hellgate Treaty, the in-stream flow rights are senior to the irrigation project water rights, and there is not an obligation on the part of the BIA to essentially equitably allocate water between the two. What the FIT water use agreement is geared toward doing is exactly that sort of allocation that the Ninth Circuit said did not have to happen. And the reason that is happening, the reason that we're talking about rolling that in as part of these negotiations, is that we are bargaining for the protection of existing users, including irrigation project users. The tribes, as part of their proposal to us 5 years ago, recognized the importance of protecting those existing users as well, and the entire process of the FIT water use agreement has been a negotiation over how that balance between the in-stream flows and the project use is to be struck. But there is this federal overlay, this case law backdrop. If we are not successful in these negotiations, that is very clear law in the Ninth Circuit about the relative priority between those two things.
Okay, I just wanted to make sure that everyone understood that somehow or another there seems to be some sort of limitation with regard to further development of any irrigation. It's almost like it's a closed basin. But to get beyond that, and I appreciate your answer, what other compact or what other tribe in the country has the right to off-reservation water?
All other tribes in the country that have the same language that shows up in Article 3 of the Hellgate Treaty about usual and custom locations. The Klamath tribe in Oregon, I'm pretty sure most of the Oregon tribes as well. I'm most familiar with Klamath because that's what's generated the most litigation. Tribes in the Pacific Northwest, many of the tribes along the Washington coast. The Nez Perce tribe in Idaho, probably also the Kootenai tribe of Idaho, but I'm not positive about that. But Washington Territorial Governor Isaac Stevens signed a whole series of these treaties with tribes in the Pacific Northwest in the 1840s and 50s, and all of these so-called Stevens treaties have this same language about the right to hunt and fish in usual and custom locations.
Are there any compacts that have addressed off-reservation use?
There are not compacts that we've done in Montana because the CSKT is the only tribe in Montana, the only tribe in Montana, the only reservation in Montana that has this language in its treaty. In other states, Montana is unique in having a compacting process. Other states approach water rights, Indian water rights in different ways, most of which generally involve courtrooms.
So there is a significant uniqueness to this.
Well, there's a significant uniqueness to the Montana compacting process that we've been using for the last 30 years.
Beyond the compact process, there's a significant uniqueness to this compact on this reservation.
Not in terms of recognition of the tribe's right to water off the reservation and the fact that we are taking some creative ways of doing it. In Idaho, in the Nez Perce settlement, for example, the state of Idaho had a lower court decision that was on appeal to the Supreme Court at the time that they settled.
You're deflecting me, though. I said.
No, I'm trying to answer your question, which is that I think that your characterization of this as specifically unique is wrong, because there are many other tribes in the Pacific Northwest that have this language in their treaties and have had their off-reservation water rights recognized by courts. We try to avoid courts in Montana, so that's the distinction you're making. Yes, that's different.
Yes, my direction was with regard to the water compact process within Montana, and that part of the question didn't extend beyond the state of Montana, so.
I apologize then, but what I will say is that the CSKT was the only reservation in Montana that has this language in its treaty that makes it inherently unique in Montana, which is why we are dealing with this issue here, and we have not dealt with this issue in our other Indian compacts.
In a previous meeting, I asked if there was a possibility of coming up with a side-by-side chart where we assumed that there was going to be water adjudication that did not involve a tribe, and then on the other side of the chart have what was going to be supplanted in that process by this compact, so that you have a comparison of before and after, so to speak. Have you been able to do that?
I have not yet had the opportunity to do that. I do recall your request, and it is on my to-do list. I have been the last few weeks traveling around western Montana talking to folks about this, and also working with the tribes in the United States to fill in those gaps in the settlement so that there are a complete set of documents. We've heard your request, though, and we will try to respond to it as soon as we can.
I think it would be very helpful to everybody so that they know what is being, I got to choose my words carefully here, what is being surrendered or capitulated or given up by someone who's not a tribal member.
That's a little bit different than the way you phrased your request last time. I only make that point, Chris, because what is important to bear in mind is that when you're talking about what is being supplanted or given up, the left-hand side of your chart of what the status quo is, as opposed to the right-hand side of your chart of what we're proposing to do under the ordinance, the left-hand side of your chart is blank. There is no body of water law as it pertains to new appropriation rights that applies on the Flathead Reservation right now. The Montana Supreme Court has taken white out to the Water Use Act on the Flathead Reservation.
I'm still trying to see what the difference would be for a Montana citizen if he was not on a reservation, and if he had to go through whatever adjudication he had to do with the DNRC for any kind of water rights application, and as opposed to what is being prepared.
And that's what you asked for last time, and that is what we will prepare about the comparison between what the Water Use Act says as it applies off the reservation and what the ordinance says as we're proposing to have it apply on the reservation. And we will respond to that as soon as I possibly can get to it.
Glad you recognize that. Let's see here. Would you agree that the amount of water being claimed in the compact is well over 2 million acre feet? Or has anyone put some numbers to that to try and figure out what it is?
You know,
I played around with it and just trying to figure out, and it's kind of tough because you guys really haven't approached quantification the way it's been done on the other compacts.
No, and the reason, and what we've done instead, and I touched on this before in talking about abstracts, in the other compacts, we've used big round numbers essentially as to what the gross quantification is, and what we are doing here is in fact much more specific. Each of the water right abstracts specifically have a flow rate associated with them.
Would it be fair to call this inverse or upside down quantification?
No, I don't think so. What this in fact is a more precise quantification that tracks very exactly how other water rights in Montana off the reservation are decreed. The abstracts are the legally controlling document of all water rights in Montana. When a temporary preliminary decree or a preliminary decree comes out from the water court in a basin anywhere in the state of Montana, what the decree consists of is the initial abstract of each of the water rights claims that were filed in the adjudication. What we in fact are doing here, that we have not done in other compacts, that we have left for later implementation in other compacts, is the specific legally controlling documents about exactly what the parameters of each and every water right that we're recognizing in this compact are. That's not an inverse quantification, that's not an upside down quantification, that is in fact an extraordinarily precise quantification, more precise in fact than we've done on any of our other Indian compacts.
Well, it's more precise in some regards perhaps, but still, the quantification for the tribe of the reserve water rights requirements is up for grabs somewhere in here, and you can sit down, well, I'm trying to come up with a number, and we've got over 2 million acre feet. I don't know how else to quantify it. So it just puzzles me a little bit. When you, notwithstanding the possible cloud or controversy raised by Lloyd Ingham about your conflict of interest, when you were we're past that, but who hired you and what were your marching orders in 2004 when you came on board?
I was hired by the Reserve Water Rights Compact Commission to serve as a staff attorney to the Commission, to provide legal advice to the Commission in various of its water right negotiations, and to carry out other duties as assigned.
Short version in one sentence. What are you?
That wasn't short version.
Yeah, well, okay.
I've been doing it for the last 9 years. You got me some beer first.
Yeah, well, maybe we'll do that someday. But anyway, if you had to put in one sentence, what is your margin on it? Like an arbitrator, are you assigned to get this thing resolved no matter what? Like two people going through a divorce, and you go from one room to the other room and one room to the other room, and you come back and say, okay, both of you got to give, and this is what we're doing. Is that what you're trying to do here? Is that your marching order?
Would you like to hear from the person who gave in?
I would love to hear it from you. You were going to be the next guy I was going to ask, so get out of the chair and talk to me.
You want to do a short sentence?
Yeah, give me the short one first. If I like detail, I'll ask for it.
Okay, our marching orders were exactly what Jay said.
Which one? Say it again, please. Repeat what he said.
What he said, he was hired to be a staff attorney for the Reserve Water Rights Compact Commission, and in that capacity to give us legal advice with respect to the issues surrounding various compacts, including this one.
Okay. What was your marching order?
My marching order is in the statute.
Is to do what?
It's in the statute.
It's in the statute.
That created a compact commission.
So,
and our marching orders are to enter into negotiations on a government-to-government basis with the United States and the Indian tribes in Montana, with the objective of achieving an equitable division of the waters between the state's water uses and those water uses that are protected as water rights by federal reserve water right law.
okay, and your representation is a direct reflection for, on behalf of the residents of Montana?
I would say it's an indirect, because we take our marching orders by statute from the governor.
From the governor, okay.
And then the governor, in turn, is the elected executive of the state of Montana. He sits at the head of the executive branch and has all executive responsibilities associated with that.
I understand that. Has it ever come up in conversation that perhaps there should be an independent lawyer that should be assigned to directly represent the people of Montana, tribal and non-tribal, as opposed to your marching orders?
Come up with whom?
An independent lawyer that is not necessarily directed by the Attorney General.
You said, has it ever come up in conversation? I guess my question is conversation with whom?
Well, within your groups, or with your conversations with the governor and with the Attorney General.
No.
No. Does that sound like a reasonable thing to you?
Does what sound like a reasonable?
Having an independent lawyer representing strictly the residents of Montana, tribal and non-tribal, as opposed to your indirect representation that you just acknowledged.
Does that sound reasonable? Sure. Is that what the legislature provided for? No.
It probably not, but it probably should have.
Well, I debate you on that point, but,
Well, over a beer perhaps. Moving right
well,
along.
I don't drink beer, but that's okay.
Well, what do you
I'll
drink?
drink his beer.
I drink, well, it's a long story, but I don't consume alcoholic beverages.
Oh, geez, well, okay, I'll let you sniff my bourbon though, it smells really good.
Well, I'd say I'm neither a Mormon nor a recovering alcoholic, if that eases anybody's minds, but I don't drink.
I'll buy you an O'Doul's, how's that?
That'd be great, I love an O'Doul's, sure.
What's that all about? We don't need to hear that kind of stuff.
I'd agree. I'm just answering the question.
Get back to what we come to listen for.
We will.
Chris, I'm actually asking you the same thing I asked you.
Yeah, I understand, I got more, but
Hop back up after other folks have.
you get a break because I gotta leave by 9 o'clock, so I'm sorry.
Thank you. We'll be in Pablo at 9 in the morning. We're doing the same show.
Okay.
I looked through this and I see all kinds of water rights, but I don't see anything that addresses secretarial rights. Maybe I missed it, I don't know. But my question is, will secretarial rights not under the project, how will they be affected? Or will they be affected?
Jennifer, David?
How will they be affected?
My question is, will they, and if they are, how will they be?
Bound to unplug something. I apologize when that happens.
What are secretarial rights?
Yeah, what are
That is why I'm handing this over to the lawyers of the United States.
I'll let them address it.
Okay, very good.
Secretarial water rights are evidence of water use on the reservation that occurred prior to the construction of the Flathead Indian Irrigation Project. Because people were complaining that the private ditches were being disturbed by construction of the project, the Secretary of the Interior in the early 1900s established commissions to document what water uses were made of those private uses and ditches so that they could be protected or incorporated within the project. You have several categories of uses remaining today, and I think the question was, those outside the project, how will they be impacted? I'm answering for the United States, so I'm subject to correction. It's my understanding the United States has come to the position that those secretarial water rights or claims of use that occur on fee simple or private lands need to go to the water court. And claims should have been filed with the court because they're non-trust kinds of rights. Those secretarial water rights impacting trust lands that have remained in trust all these years will have the water right and be limited by the conditions of the secretarial decision. So if it was for a small acreage for irrigation, there was a period of use, that's the extent of the right. And expansion of that right can occur under the appropriate law. Those water rights, secretarial water rights that are served by the project will be subject to the FIT water use agreement. And if the water is delivered by the project, will be subject to the FTA limits if those are finally agreed upon.
So, if I should someday not have my water, then what's the procedure?
Are you on private land?
Yes,
Did you file a claim with the Montana Water Court?
yes. Well, did I file for a water right?
Yes.
Yes.
Well, then the water court will adjudicate your claim.
Okay, all right. And they'll let me know on that?
Yes,
Okay.
I assume they will.
Now, if you filed an adjudication, it will be decreed as part of the water rights in basin under 76L or 76LJ, which are the names of the two water court basins that include the Flathead Reservation.
Just a little bit to follow up. Those folks of you out there who have water uses and you file claims for the adjudication with the water court, what we're discussing here, this compact, will not affect that process whatsoever.
Seeing none. David, sorry, hold on. Thank you.
We don't have a podium here, or it's just stack stuff on it, I'm just gonna move this thing. Accommodate that. William G. Myers Jr. I operate several businesses in Big Fork, and I've battled both the tribe and the state before, so that's not like I'm picking on one or the other. I'm here representing Bayside Park and Marine Center. I'm one of the members of Bayside. A couple of questions for you and tribal members here, if possible, to get some answers. You represented that the document here would have to be approved by the Congress of the United States. Is that right? You made reference to Article 5. Is that correct?
I think Article 7 is actually one that talks about finality, but yes, ultimately, the Indian water rights settlements that we do in Montana need to be approved by the state legislature, by the tribal government, and by the United States. Generally, but not always, that is Congress.
Your PowerPoint talked about number 5. It said Article 5 was where it referenced that the Congress, and I think I took it down as quickly as I could. The U.S. can only be bound when the Congress acts, I believe, was the PowerPoint presentation.
Yes, that would be one of the disclaimers in Article 5, that we are not purporting to bind the United States because we recognize that the state legislature acting alone and the tribal government acting alone does not have the legal authority to bind the United States. Only Congress can do that.
Okay, and where specifically do you have that in this document then? If it's not in 5, if it's in 7?
No, that piece is in 5. The disclaimer that says that only...
I'm looking at 5. Where in 5?
Can you hand me your copy?
You might look under 4. It could be under 4.
If you look in Article 5B on page 39 of the draft, portions of that,
Article 5B on page 39 of the draft, subsections 10 and 11 both deal with some of that, which is nothing that we're doing here. Constitutes a waiver of sovereign immunity by the United States, except as expressly set forth in 43 U.S.C. 666, which is the McCarran Amendment, or otherwise provided by Congress, or except as expressly provided herein and as may be required by Congress to modify the obligations of any agency of the United States. So both of those speak to that.
Is it also affected by A, Section 4, on the previous page, on page 38, except as provided herein and authorized by Congress?
The language there on page 38, Article 5A, subsection 4, is that nothing that we are doing in this settlement, except for what we specifically say we're doing, which has to do with the recognition of the tribe's off-reservation water rights, which again also need to be authorized by Congress as part of the settlement, in any way establishes the nature, extent, or manner of administration of water on federal lands outside the Flathead Reservation. So again, we are not changing anything that presently exists in federal law as it pertains to federal lands without congressional action.
Okay, so am I correct in reading then at the beginning, except as provided herein and authorized by Congress? So this would be something that would be authorized by Congress before it would be before it take effect. Is that correct?
Yes, if you look at the definition for effective date in Article 2, the effective date of this settlement only occurs after the state, the tribes, and the United States, and the United States acts through action of Congress as signed by the President, only until all three of those sovereigns have approved the settlement. The effective date only occurs after the last of those three sovereign approvals in whichever order they happen.
Right, okay. So that would be effectively the same as when the treaties were signed, there had to be approved by Congress. Is that correct?
You know, I gotta be honest with you, going back to the mid-19th century, well, the Senate is actually the body that approves treaties, the House of Representatives didn't. And then in 1871 or 72, Congress essentially said no more treaties with Indian tribes, which is why subsequent things were done by executive order or congressional action.
Okay. This question would be directed to a member of the tribe. Do we have someone here representing the tribe tonight? Okay. I notice in this document, at the outset, there's reference to the Treaty of Hellgate, as it's called.
Yes.
But no mention to other treaties, specifically no mention to another treaty done during that same time period that's generally referred to as the Upper Missouri Treaty in the tribe's own treaties and statutes.
We call it the Common Hunting Ground Treaty, and it's actually an agreement between the tribes as to how hunting will be conducted for 100 years. It doesn't have anything to do with water rights.
I would beg to differ. I think if you look under Article 8 of that treaty, you will find it specifically mentions, including the use of and the navigation of all lakes and streams shall be forever free to citizens of the United States.
And is that the treaty that expires after 100 years?
I think that it actually pertains to remuneration that expires after 99 years to the black.
I think the treaty has been determined to have expired.
And where have you found that to be?
I can't recall the exact case, but yes, it's my understanding, the interpretation of the treaty is that it's no longer effective. I can't quote you the case.
Yeah, I'd like to know that because as I understand this is a valid treaty. And the only reference that I have found in it was in terms of remuneration.
Could I see the treaty?
Expiring after 99 years.
If access is your concern, determination of our water rights doesn't affect access by non-Indians to waterways.
You see where it's 99 years, this will expire? I the only period is right there, 5 years.
Yeah.
You want to read that then? You want to?
Well, this is the provision of the treaty in Article 4. The parties to this treaty agree and consent that the tract of the country lying within the lines drawn from the Hellgate or Medicine Rock passes in an easterly direction to the nearest source of the Muscle-Shell River, and it goes on to describe the extent of the treaty. Talks about, however, subject to the provisions of the third article of the treaty giving the right to hunt and prohibitions to the establishment of permanent villages and the exercise of any exclusive rights within 10 miles of the northern line of the common hunting ground drawn from the nearest source of the Muscle-Shell to the Medicine Rock passes for the period of 99 years. So the hunting provision of the treaty, which I was referring to, has expired.
Okay, thank you.
And the remuneration portion, did you want me to read that as well? I guess not.
No. What I would like, though, as I understood what you were commenting on, is that, if I heard you correctly, you said a moment ago that the treaty expired after 99 years.
The common hunting ground provision.
That provision of the treaty, okay. So the treaty is still in effect.
I believe that there are interpretations to be drawing a different conclusion, but again, I can't recall them. I'd have to do some research.
Okay, that's fine. I would just suggest then that perhaps, since one treaty is mentioned, other treaties that have mention of water rights, and very specifically in Article 8 of that treaty, where it says, and that the navigation of all lakes and streams shall be forever free to citizens of the United States. That is effectively a water right that thereby pertains to citizens of the United States.
No, that's not a water right. There's a very different body of law.
It's a
that
treaty
governs
right. Treaty right.
But navigability, there is a whole, and I'm happy to hand this over to Candy. You can talk at great length.
We don't need to go. I understand.
My only point to you is that when it refers to navigability, that is a whole separate issue and a whole separate legal doctrine than anything having to do with the quantification and adjudication of water rights, which is what we're doing here. And the judicial determination is that the legal source of the tribe's water rights begins with the Hellgate Treaty, the legal recognition of it.
The reason I bring this up very specifically is that it seems to me in this document here, it talks about areas off of the reservation.
Mm-hmm.
Specifically, and I'm only going to deal with one right now, the Swan River. It says here the tribes have an in-stream flow water right for the reach of the main stem of the Swan River, which I've never heard exists right now. Is that correct? This is a granting of a new right, is that correct?
Absolutely not.
Then where is that quantified previously?
It's not. That is exactly why.
Exactly.
No, not exactly. Can I have the mic for me?
That's what we're trying to do.
Thank you.
The reason that the Compact Commission exists is that as part of setting up the general stream adjudication, the legislature also required the quantification of Indian and Federal Reserve water rights. In 1908, in a case called Winters versus the United States that arose off the Fort Belknap Reservation, the United States Supreme Court held that as a matter of federal law, whenever land is taken out of the public domain and set aside for a federal purpose, it's a national park, whether it's a national forest, whether it's a Fish and Wildlife Service refuge, whether it's an Indian reservation, sufficient water to satisfy the purpose or purposes of that reservation is implicitly reserved as well. So there is the legal doctrine that says these are water rights. These are water rights with a priority date of the date that the land was taken out of the public domain. So in the case of the Flathead Reservation, that's July 16, 1855, which is the date of the Hellgate Treaty. There is a water right under Article 3 of the Hellgate Treaty that's been litigated out of other treaties in the Pacific Northwest, including Klamath, that extends to off-reservation water rights for fishing in the tribe's usual and custom locations. That also is a legally valid water right that has not, as a matter of federal law, been quantified. It exists as a matter of federal law simply because people were not aware of it or chose not to pay attention to it. Doesn't mean that it does not exist as a matter of law. And what we are tasked with doing by the legislature is negotiating the final quantification of those water rights. Because if we are not successful in that task, they need to be resolved through litigation and adjudication. So your statement that this is a granting of a new right is not correct.
To sum up what you just said, if I can, you're talking about quantifying, and is better phrasing of the terminology. Is that correct?
Yes, absolutely.
And I don't have a question on that. I've participated in this over 10 years ago, so I just haven't been involved recently.
Yeah, just one other point that seems logical to me anyway. If you're in reference to the right that you were describing in the earlier treaty, that the language that seems to preserve forever the right of the citizens to navigate on lakes and streams, the creation of an in-stream flow right, which requires that water remain in the Swan River, seems to me would help your right to navigate the Swan River. So, to the extent there's a treaty right that deals with navigability, an in-stream flow right is actually complementary to the navigational servitude, not in conflict with it.
That may be true. And
That is true.
It may be true. May be true, Chris. I don't have a doubt that it may be true, okay? But I think what is more of concern to me is under this section E, where we're looking at 2 mainstream in the Swan River, and then subsection E. it says the tribes of the United States on behalf of the tribe shall be entitled to make a call to enforce this water right only against junior users, the purpose of whose rights is irrigation and whose source of supply is surface water, which I believe is what you're referring to, is that correct?
Sure, I mean, if there's an in-stream right, and that prevents surface flow rights that are junior from dewatering the stream so you can't navigate.
I understand that.
Okay.
I understand. I'm just clarifying that that's what your point is that by them making a call, they would preserve the water flow, is that correct?
That's correct.
Okay,
And
so,
for folks in Big Fork, when the Swan River has an in-stream flow right on it, that means there's actually gonna be water emptying into Big Fork Bay out of the Swan River.
I understand that. The question I have is, as a result of this, has notification been given to those who will be directly affected by this, who have water rights as they exist today?
That's exactly the process that we're engaged in now. That is the public review process that we are in. That is why we are holding meetings on and off the reservation. It is why we are widely publicizing the fact that this settlement is occurring and potentially affecting the basins that it affects. One other piece of context that I would note is that, and we did not have the proposed abstract and a technical document for the Swan River in-stream flow right on the reservation 2 weeks ago. It is there now. The level of that water right is set in such a way that it is essentially satisfied by operation of the existing PPL dam right, and that the quantification point for that right being below the mouth of Big Fork Lake, again, goes a long way to ensuring that, as a practical matter, sufficient water is already there, with the existing uses already taken into account to satisfy that water right. And so again, that is part of the balance that we're trying to strike between the recognition of the tribe's legal entitlements to water in a way that protects existing users. And we believe that we've done that very carefully in the Swan, as well as in the Kootenai on the Clark Fork, through the combination of the call protection language, which means that all non-irrigation rights can't be called in the first place, with the levels at which those rights, the enforceable levels of those rights are actually set, which based on the hydrologic work we've done, are generally satisfied under current conditions, including existing uses.
Except for those who are irrigating from surface water, which would be the direct flow of the Swan River.
No. Those folks are legally, it is theoretically possible that the tribes could call them. The tribes are not waiving their legal right to make a call against those folks, but as a practical matter, because of how we are proposing to quantify the levels of in-stream flow, the enforceable levels of the in-stream flow water right, which is Appendix 22 of the compact. It's in the binder on the back table and it's on our website. The actual level that flow is set at, based on the gauging data that we have collected from the Swan and based on the operation of that PPL storage right, is such that that right, at the level that the tribes are entitled to exercise it, and if it drops below that right, that's when they can make call, that right is actually satisfied under the existing flow conditions on the Swan, including those irrigation uses and all of the other uses that are already there. We are not trying to quantify a right that is going to materially change the water budget in the Swan, because fortunately the water supply in the Swan is pretty good. And so we are able to strike that balance here between the recognition of the tribe's legal water rights and the protection of existing users in a way that in fact is able to accomplish both of those things as a practical matter from day one.
After all that you just said, my question still remains. You said two different things, theory and actually. So you're saying in theory there could be a call, but you're saying actually it wouldn't happen.
That is exactly what I'm saying.
My comment is that then if it's possible in theory, there could be a conflict.
Yes, that is theoretically possible.
Why not resolve that now?
How would you propose doing that, where what we are trying to do is balance the recognition of a legally valid senior water right in a way that allows junior water rights to continue to be exercised in a prior appropriation state, where as a matter of the baseline law that we have, the senior water right doesn't have to care about those junior water rights? What's the alternative?
The alternative is to, instead of going from theory to actual, resolve the conflict therein.
Right, what is your proposed resolution for that conflict?
Well, anyone that has a water right right now would be guaranteed that water right. Whereas what you're proposing in this document, if I'm reading it correctly, and you just acknowledge it's true, is you're saying that a call could be made against someone who has a water right.
That is correct. The call could be made against someone who has a junior water right by someone who had the tribes who have a senior water right, which is exactly the same way the water law works in the rest of Montana. If David has a water right that is senior to your water right in state law, David is entitled to the last drop of his water before you're entitled to the first drop of yours. And if you're upstream from David and he wants you to shut off because he's not getting his water, he shuts you off under state law. We're trying to avoid that scenario.
An expansive definition of senior water right here.
No, I'm using a textbook black letter definition of senior water rights under federal law that tribes water rights for consumptive uses track back to the treaty date of July 16, 1855. And for
based on the hunting or fishing right, Article 3.
Right. No. For on-reservation consumptive uses, that has nothing to do with the hunting and fishing. Hunting and fishing will take you off the reservation.
I understand.
But the priority date associated with
We're talking about something off the reservation, consumptive use now.
No, we're not talking about consumptive, we're talking about in-stream flow use. That's water staying in the stream, not being taken out of it and lost to the system. And those sorts of water rights under that Hellgate Treaty language have what is known as a time immemorial priority date, which just legally means that they are first, period.